Hi, I'm Todd Smithline, and welcome to Smithline Training's Contributing to and Releasing Open Source. This is the third episode in a 3-episode series on open source. In the first episode, we explained how open source licenses work, and we divided them by license type. In the second episode, we taught you how to create an open source policy for your company. And today, we'll talk to you about what you should consider if you want to contribute to third-party open source projects or even release a project of your own. Now, a quick disclaimer, Smithline Training LLC is not a law firm. And while we'll be talking about legal topics today, we are not providing legal advice. Likewise, when you interact with Smithline Training or attend one of our programs, no attorney-client privilege is created. And as always, if you have particular legal questions, you should consult with an attorney. We follow a 2-step training approach at Smithline Training. First, we have you watch the episode, as you're doing now, and then we invite you to attend one of our roundtables. Now, we hold these roundtables online or in person at our offices in San Francisco. And the great thing about the roundtables is that it gives you an opportunity to ask questions about the episodes and also to share best practices with other program participants. We welcome your feedback, your questions, and even your occasional complaint at help@smithlinetraining.com. Now, we provide a checklist, form, or other tool with each episode, and we have 2 tools for you today. The first is our open source contributions questionnaire, and the second is our open source project release questionnaire, and I'll talk more about those throughout the episode. So what are we going to talk about today? Well, first we'll look at the big picture. What are open source projects and how do they operate? Next, we'll discuss the legal implications for participating in open source projects, particularly for proprietary technology companies. After that, we'll address contributing to a third-party open source project and give you some examples of contributions that your engineers might want to make and help you walk through an analytical process for deciding whether or not that might be problematic for your company. And then we'll do the same thing for a request to release a project. So let's start with the big picture. What are open source projects and how do they work? Well, an open source project is a volunteer operation that releases source code through an online repository. And the project will choose a license under which that code is made available to the world, and that's called the project license. A project is led by a project lead. Project leads can be individuals, they can be nonprofits, and they can be corporations. The project lead makes an initial contribution of code to the project, and that's the code that starts the project out. Third-party contributors then contribute bug fixes or even whole new modules of code to the project, and they typically do that under what's called a contributor agreement. And we'll talk more about those in a minute as well. So let's take a look at what an open source project actually looks like. This is a project called Enjarify, and you can find Enjarify on a repository called GitHub. Now, Bitbucket and SourceForge and other repositories also host a lot of open source, but for this particular example, we've just chosen Enjarify, and you can find it on GitHub. So here we go. You can see that the project name is Enjarify. You can see that the project lead is Google. They're the initial contributor of the code. They're the project lead. You see here that if you click on code, you can get access to the code and download it. The project will identify its project license. In this case, the project license is found under a tab called license.txt, and the license this project has chosen to use is the Apache license. So they set forth the full terms of the Apache license right there in the repository. Here you see contributors. Now, there are only 4 contributors shown here. This is a relatively small project, but there can be thousands of contributors to open source projects. And the contributors initiate what's called a pull request. And this is the way the contributor says to the open source project, hi, I have some code I'd like to contribute. I've made some bug fixes and I want to upload them. And the technical way they do that is through what we call pull request. The legal way code gets into an open source project is typically through what's called a contributor agreement. And for Enjarify, you can see here under contributing.txt that there are some instructions as to what to do if you want to contribute to this project. And those instructions tell you that if you want to contribute to Enjarify, you need to execute a contributor license agreement with Google, the project lead. So to recap, there are really 2 ways that a proprietary technology company may want to interact with an open source project. The first is you may want to contribute to an existing project, and you do that by making contributions, typically under a contributor agreement, to the project. The second way is you may want to release your own project. In that case, you're going to become the project lead. You're going to make the initial contribution to the project. You're going to choose the project license. So in the example we just saw, the project license was Apache. And you're also going to choose the contributor agreement, the form under which contributors are going to submit their changes back to the project. So what are the legal implications of either contributing or releasing open source? And in particular, what are the legal implications for a proprietary technology company? Because that, of course, is our focus under this series. Well, whether you're contributing to an existing project or releasing your own, there are a couple things you want to keep in mind. First is that you're going to be entering into binding legal agreements. Secondly, you're going to be granting intellectual property rights. And third, you're going to be waiving trade secret protection. And the reason for that, of course, is open source is source code. It's human readable. So if you contribute open source to a project or you release open source under your own project, either way, the code is going to be readable, and any trade secret protection that might have adhered under that code will be waived. And by the way, this is something your engineers are probably already doing. They're most likely already contributing to third-party projects, and perhaps they're even releasing their own projects as well. So given these legal implications, given that you're going to be entering binding legal agreements, granting IP rights, and waiving trade secret protection, this is something you're going to want to have a process for within your company and make part of your open source policy. So given these risks, how do you manage the risk? Well, the first thing you're going to want to do is gather the facts. And we'd recommend you do this through the questionnaires that we provided. There's the open source contribution questionnaire and the open source project release questionnaire. And hopefully you have these in front of you. If not, you might want to download them now and walk through the questionnaires as you watch this episode. But the open source contribution questionnaire asks a series of questions about the code that your engineers want to contribute to the project, as does the open source release questionnaire. And the open source release questionnaire asks some additional questions about who's going to manage the project and what license are we going to release the code under, and what contributor agreement are we going to use. So after you've gathered the facts under these questionnaires, we'd recommend you ask 3 questions. The first is, what are the legal terms of the contribution our engineers want to make? Second, what's the nature of that contribution? And third, how does that contribution relate to the company's own products or own intellectual property? Those are the 3 questions we think you should ask, and you apply them to either the contribution or release request, and we hope that that will help guide your answer as to whether you want to make that contribution or you want to release that open source project. So let's take a look at this from the perspective of contributing to an existing project. As I said, the first question you're going to want to ask is, what are the legal terms under which we as a company are making this contribution? And as I mentioned before, that's most likely going to be under what's called a contributor agreement. Now, a contributor agreement comes in a couple different versions typically. There's an individual version and a corporate version. And what I want to note here is that when your engineers are participating in open source projects and contributing to these projects, and entering into contributor agreements, they are in fact binding the company to legal agreements that deal with intellectual property. And that is why it's important for you to properly manage this activity that you enter into corporate contributor agreements and not individual agreements. Many projects have a corporate agreement, and you can sign that once at the level of the company and have it apply to all activity between your employees and that project. So again, contributor agreements typically come in both an individual and corporate version, and you may want to use a corporate version to manage all of your activity with a particular project. Secondly, it's important to note about these agreements that the agreement is actually with the project lead and not the project itself. That means you're giving the licenses that you're going to give in your contribution, in some cases to a company. In the case of Enjarify, the example we just looked at, you'd be giving those licenses to Google. You're not actually giving it to the project. You're giving it to the entity or individual who's running the project lead. The third thing to know about contributor agreements is that there are a few different types of agreements, and I'm going to explain each of them to you in just a minute. By the way, contributor agreements are sometimes referred to as contributor license agreements or CLAs. Now, there are 3 models of contributor agreements. The first model is the license model. The Apache Foundation uses the license model for the projects that it operates, and Google has also adopted the Apache Foundation's form of contributor agreement for both Enjarify, the project I just mentioned, and Android. In fact, the Apache Contributor License Agreement is in very widespread use in the open source community. Under the Apache model, or the license model, you grant a broad copyright license in your contribution to the project lead. Importantly, you also grant a patent license to the project lead. Although I would note that with respect to your patent license, there is defensive termination, meaning that if you've granted a patent license to the project lead and you are then sued based on your contribution, the licenses you granted under your patents with respect to that contribution terminate. The second model is the joint ownership model. Now, Oracle uses the joint ownership model for Java. And what's different about the joint ownership model is that instead of granting a copyright license, you are actually granting joint ownership in your contribution to the project lead. And in this case, Oracle has decided that there will be no duty to account, but you will still otherwise be operating as joint owners of the copyright in your contribution. You also grant a patent license under the joint ownership model. Note that that patent license is sublicensable and there's no defensive termination. So again, the second model is the joint ownership model. This is used by Oracle for the Java code, and that's our second model. The third model is the assignment model. Now, the assignment model is what's used by the Free Software Foundation, the authors of the GPL. And under the assignment model, you actually assign copyright in your contribution to the project. So it's not a license, it's not joint ownership, it's straight assignment. And by the way, you get no license back to your contribution. You also grant a broad patent license. To summarize this on contributor agreements, the license model, the model under which you grant just a license, both copyright and patent, is likely to be the only acceptable choice for most proprietary technology companies when they're contributing to third-party projects. As I mentioned before, we recommend you use the corporate version so you can enter into this agreement once at the corporate level as opposed to at the individual employee level. Now, sometimes no contributor agreement will be specified at all. In that case, we'd recommend you ask the project lead, what are the terms under which I'm making a contribution? In that case, your engineers will be executing a pull request, uploading code to the project, and you're going to want to know what are the legal terms under which we're giving that code to the project. Sometimes the outbound license will equal the inbound license. And what we mean by that is that the terms under which you're making the contribution to the project will be deemed to be the same as the terms under which the project itself is releasing that code to the world. For example, the Apache 2.0 license contemplates just this situation. It speaks to contributors, and it provides that contributions made to projects using that license are taken into the project under the Apache license. But that is not the case with all open source licenses, and is really something you're going to want to clarify on a contribution by contribution basis if, again, no contribution agreement is specified at a project to which your engineers want to contribute. The second question you need to ask is, what is the nature of the code? What is the nature of this contribution I want to make to the project? And a couple pretty straightforward but important questions you're going to want to ask here. First is, who created this code? Was it created by our employees? Was any part of this code created by third-party contractors or maybe somebody else? And you're going to want to know the answer to those questions, of course, because you're entering into a contributor agreement. You're granting a license to the project lead, so you're going to want to make sure you have sufficient rights to grant those licenses. The second set of questions you're going to want to ask is, what is this code? Is this modifications to the project's own code, or is this whole new code we're contributing to this project? And if it is more than just bug fixes to the existing project code, is this really something we as a company want to be doing? The third question is, what's in this code? Is there other open source in the code we want to contribute? And this can get very tricky because it's hard to combine different types of open source together and then hand them over to somebody else under a contributor license agreement. The licenses are all not compatible with each other, and you just need to be very, very careful when you're doing that. You also need to ask, is there any third-party proprietary code in the code I want to contribute to the project? This will not work at all. There's really just no way to take proprietary code and turn it into open source. So if your engineers come to you with a contribution they want to make, and they tell you that they've included proprietary code in the contribution, that proprietary code really needs to come out before you make their contribution. The last question, the third question you want to ask, and perhaps the most important question, is how does this contribution relate to our existing or planned products or intellectual property? And if the answer is yes, if the answer is that there is some relation between the contribution and your company's own products or your company's intellectual property, you need to be very careful. And you need to ask yourselves, for example, will making this contribution hamper our ability to protect our own intellectual property? So if we make this contribution and disclose this code, will it start the clock on a patent application that we might have wanted to file with respect to this technology? Will making this contribution somehow have a negative impact on our sales or product strategy, or otherwise in some way help a competitor? So again, if the contribution relates to either your own products, if the code you want to contribute performs functions similar to what your own products perform, or if there's overlap between the contribution and your own intellectual property, we consider that to be a related contribution, and you're going to want to stop and think very carefully about that. So we've talked about how to use the open source contribution questionnaire, and we've talked about the 3 key questions we think you should ask when your engineers want to make a contribution. Now let's go through some example contributions and see how we come out. We're going to use ServiceHR as our hypothetical here. Now, you may recall from the earlier episodes that ServiceHR is a SaaS company that has a service which helps its customers manage their employee data. And ServiceHR's customers access the application, the SaaS application, both through a website and a mobile device. ServiceHR decides to implement the open source contribution questionnaire, and they set forth some initial guidance for their developers on contributing to third-party open source projects. So ServiceHR has set forth some basic guidance for its developers on making contributions to third-party open source projects. And they've divided this between related and unrelated contributions. And for unrelated contributions, what they tell their developers is that this is generally going to be an acceptable activity, but they're going to check each time for IP product and competitive concerns, and they're only going to allow contributions under a license model agreement, like the Apache Contributor Agreement. For related contributions, they're going to be a lot more cautious. They're going to allow related contributions only on an exception basis, and only if there's really no impact on their product strategy or their intellectual property strategy. And finally, even if they're going to allow related contributions, it's only going to be for minor things like bug fixes and under a license model. So that's the basic guidance that ServiceHR starts with to its developers on contributing to third-party open source projects. So the ServiceHR engineers come back and they say, look, we want to contribute to 2 open source projects. And here are the projects. The first is Enjarify, the project we were just looking at. The project lead here is Google, and the license is Apache 2.0. And the second project is a project called Cocoa Lumberjack, and the project lead is Dootsie, and that project is licensed out to the world under the BSD license. So in order to determine whether we should make this contribution, we would suggest you follow those contribution questions. And the first one is, what are the legal terms under which we would make the contribution? And in this case, you would look at the questionnaire filled out by the engineers and see if they've identified a contributor license agreement, or you just go to the site and look at the contribution terms. And as we saw before, the contribution terms for contributing to Enjarify are the Google Individual Contributor License Agreement, and that license agreement is based on the Apache model, so it's our license model agreement. Here, they note the Individual Contributor Agreement. Of course, as a company, you'd want to do that under the corporate agreement, but they're basically the same agreements, the individual and the corporate version. The only difference is that under the corporate version, there's a schedule where you list each of the engineers who would be able to make contributions to that project. So we know the contribution terms, and the contribution terms, again, are the Google Contributor License Agreement. The next question is going to be, well, what's the nature of the contribution? And again, we'd look at the questionnaire filled out by the engineers under nature of contribution, and we'd see what they tell us about how this contribution was created and what's in the code. And they come back and say, look, employees created this contribution, and there's no third-party open source in it, and there's no third-party proprietary code. And they also tell us that it's only bug fixes. So they haven't added any new code here. They've simply modified the existing project code. Okay, so well, that's all well and good. But then we still need to ask the final and perhaps most important question, which is, does this contribution relate in any way to our own product or our own IP? And in this case, again, we look at the questionnaire and see what the engineers wrote under the section on relationship to company products or IP. And in this case, the engineers come back and tell us, look, what we're doing here for Enjarify, which is a tool for development in Android and Java environments, has nothing to do with the HR services we provide to our customers. They're really totally unrelated, and therefore the answer to the question of any connection to our IP or products is no. If that's the case, then in accordance with the rules that Service HR has set for its engineers, this contribution should be allowed, and therefore the engineers can execute the contributor license agreement. Again, remember the corporate version. The company would execute the corporate version of the contributor license agreement and make the contribution. So the second example is Cocoa Lumberjack, and Cocoa Lumberjack happens to be code that's used to log activity on a mobile application and report that back to the server. And in this case, as I mentioned before, it's under the BSD license. In this case, when you go to look for the contribution terms, what you find out is that there are no terms. So in the repository for Cocoa Lumberjack, no contribution terms are specified. So that's the first thing we need to take into account. The second thing we take into account, again, is what's the nature of the contribution. And the engineers come back and tell us, well, we created it all ourselves, but there is some new code and functionality here. And finally, to that third question, is this contribution related or not to our products and IP? The engineers come back and say, well, in fact, it is. It's not right in our core domain, but what we're doing with this code gives us a competitive advantage. It's helping our application perform better, and therefore we have to say that it is, in fact, related code. So given those answers, the answer here would be, no, we should not contribute. Now let's consider what you're going to want to do if instead of contributing to a third-party project, you want to release an entire project of your own. And it's really not that unusual for proprietary technology companies to release open source projects. There's lots of reasons why you might want to do that. One is that you may want to foster a developer community for your own project, or you may want to put out a version of your product under open source in order to interest people in buying a commercial version of the product. And finally, even if neither of those apply, creating an open source project and releasing it to the world may be something your engineers are very interested in doing, and you want to support them in those endeavors. So let's assume again that you've decided you want to release your own open source project. Well, in that case, let's remember you now become the project lead, and you're going to start the project with an initial contribution. So just like we did when we were thinking about contributing to a third-party project, here we're going to use the questionnaire to gather the basic facts, and we're going to ask those same three questions. What are the legal terms under which we're doing this? What's the nature of the contribution we want to make? And is it in any way related to our products or IP? But when you do that this time, you're going to want to pay much more attention to those IP, product, and competitive concerns because, of course, now, instead of just releasing bug fixes or making a minor contribution to somebody else's project, you're releasing an entire application yourself. So there are much greater stakes because what you're releasing is an entire program, again, and not just additions to somebody else's program. And in this case, you need to take into account that even if the answer comes back that the project we want to release has nothing to do with our own products or services, there may still be independent value, product value and IP value in that code base. So the answers are going to be a little more subtle here than they were when we were talking about just contributing. And finally, a related concern is that you're going to need to think about how you're going to bring this project to the world, what you're going to call it and what trademark you're going to use, and is that trademark in any way going to relate to the trademark for your own company. So again, the issues here are a little more complex than when you're just simply contributing to somebody else's project. The final thing you're going to need to do is choose a project license and a contributor agreement. As I said in those three questions, the first question is, what are the legal terms of the contribution? Well, here you are choosing the legal terms because you're choosing both the license under which the code will be released to the world, and you're also choosing the agreement under which contributions will be made by others back to you, the project lead, for the project. So let's focus in on this question about choosing a project license. And again, this is the outbound license under which the project code will be made available to the world. And here you really have two options. The first is a permissive license. And this is appropriate if you want to have really widespread adoption of the code and you have no concerns about how anybody uses the code. So this would be most appropriate for unrelated code. As we know, permissive licenses don't really ask much of The licensee, if you redistribute the code, you must give attribution, but that's typically the only major obligation under those licenses. So if what you're seeking to do is have the most widespread adoption of the open source code you're releasing, then you're likely going to want to choose a permissive license. Here you have two main options, either BSD or MIT, and those are the simplest, or the Apache license. Now the Apache license is nice because it's the most complete agreement, but you should note that unlike BSD and MIT, the Apache license contains an express patent license grant from you as the contributor, or the project lead in this case, out to the world. It does have defensive termination, but you're still making a patent license. So if you choose the Apache license, just keep that in mind as with respect to your patent rights in general. So the second type of license you might choose is a viral license. Now, a viral license is going to be appropriate if you want to discourage use of the code you're releasing in a proprietary application. So for example, let's say you want to release this open source for the purpose of seeding a market for another application that you're going to release, which is a commercial application. You're going to release this open source version for free, and you're also going to release a commercial version of the application. And the purpose of releasing the open source version is really just to get people interested in the product. That's called a dual model approach. And if you're going to take that approach, then a viral license is going to be the most appropriate because it's the license that's going to most severely limit what your users can do with that code. A couple things to consider if you're going to use a viral license. Now, the main viral license is the GPL, and that comes in two versions, version 2 and version 3. These are by far the most widely adopted viral licenses. You are going to need to be careful, though, particularly if you choose GPL v3, because by releasing code under GPL v3, you are agreeing to a whole series of promises about your patents that you may not want to make. You're granting a patent license, but there are also some additional obligations you're entering into with respect to patent rights that you control when you release code under GPL v3. So if you're choosing a viral license, be careful about the GPL v3 and its patent clauses if you have patent rights that you want to protect. The other option for a viral license is the Affero license. Now, as you'll recall, the Affero license is the license which defines distribution as making available over a network. So the Affero license is going to be appropriate if you want to prohibit people from taking the open source code you're releasing and using it in a way that would support a SaaS service. So once you've chosen your outbound license agreement, the license agreement for the project, now you need to choose your inbound agreement, the agreement under which you will accept contributions to the project. And here we think probably the most attractive option for a proprietary technology company is going to be the license model or the Apache model. It's very widely adopted and it grants broad rights to the project lead without asking the contributors to either assign you ownership or share in joint ownership. So it's probably the most attractive for the contributors while at the same time giving the project lead sufficient rights to run the project. The alternative, of course, would be to use the joint ownership or assignment model. And those do grant you greater rights, but understand that there are fewer people who would be likely to contribute should you use one of those models because they're going to have the same concerns you would have going in the other direction, which is that you do not want to grant joint ownership in your contribution or assign it altogether to the project lead. A few final thoughts on contributing and releasing. First, make sure both contributing and releasing are covered in your open source policy. Second, when you are contributing, you should log the contributor agreements that your company has signed and entered into, as well as the projects that are approved for contributions, so your engineers can look that up easily and know whether or not a project is one that they're allowed to contribute to in the first place. And then finally, if you do decide to release your own project, have a plan for doing that. It takes quite a bit of resources and energy to have a successful open source project. Somebody within your company is going to need to be the project lead. Somebody's going to need to manage the contributions. And if you really want to have a successful project, that takes some effort. So if you're going to release a project, we suggest you have a plan for doing that before you start down the road of releasing code. So I see the lights, and that must mean we've reached the end of another episode. I'd like to thank you for joining us, and I'd like to invite you to participate in a roundtable. You can sign up for the roundtables right here on the site on which you're watching the episode. We also welcome your feedback at help@smithlinetraining.com. Thank you.